car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis, Wright, and host David Lamb.
Hello and welcome into the attorneys. We appreciate you spending your Sunday evening with us for the next half hour. The way it's going to work is that we got a panel of experts. We're going to be dealing with DUIs tonight, helping inform us, and would love to take your questions. The best way for you to get those questions to us is to call, text, and email, and that is information that is on the bottom of the screen, and we'll be there throughout the program tonight. So encourage you to get in touch with us, pass your questions along. Also, there are attorneys standing by right now, so if you have questions and you're looking for answers, the numbers on the bottom of your screen, the way to get those questions answered. Leading our conversation, as he often does, from the firm of Hollis, Wright, Carter Clay. Good to see you, sir.
Good to see you, David. I hope you're doing well.
I am. You as well.
Yeah, driving under the influence. This is always, to me, an interesting topic from a criminal law standpoint, because DUIs don't discriminate. It cuts across all socioeconomic backgrounds, all demographics. It does not discriminate based on race, and I think that's one of the challenges that we have faced as a society over the years, is that the individuals responsible for passing these criminal laws sometimes have a little bit of a conflict of interest. They realize as they are going through and evaluating these laws concerning DUIs that they may very well be personally impacted. And so there's a little bit of a conflict in that regard, but there were some laws that were passed a few years ago that really enhanced the penalties for those individuals who were charged and convicted of DUIs, and we're going to talk about that here this evening. Just to highlight the DUI law a little bit more, I wanted to bring up some statistics because the statistics are still pretty staggering out there relative to deaths. In 2013, there were approximately 260 fatalities involved in driving-related accidents as a result of alcohol consumption, and out of those 260, there were roughly about 23 deaths of individuals under the age of 21 years old. And then that's really sad and unfortunate when you think about the parents and grandparents and siblings that were affected by the loss of a loved one, especially at such a young age. And we're very fortunate here this evening to have Jay Tidwell with us. Jay is an outstanding attorney in the Birmingham and Jefferson County area. He practices heavily in the area of criminal DUI defense work, defending those individuals who have been arrested and charged with DUIs. Jay, welcome to the show. We really appreciate you being here. Introduce yourself for a minute and tell us just a little bit about the nature of your law practice.
Thank you, Carter and David, for having me here. Yeah, as Carter said, my name is Jay Tidwell. I'm a founding member of Tidwell Law Group and focusing on criminal defense with emphasis on DUI, obviously. I've been doing this for about 11 years now, so I handle a lot of DUI cases and advising people with what to do and guiding them through the process once they receive a DUI.
Yeah, talk just in general about DUIs, the types of clients that you represent, just to sort of highlight, I think, my point that DUIs cut across all backgrounds, demographics, race, socioeconomic backgrounds, and I think you probably see all kinds in terms of your clients.
Absolutely. What you'll see in DUI is you might be representing a child or 19-year-old, 20, 21-year-old one day, and you might get a call from a doctor, lawyer, accountant the next day. I think there's a lot of people that like to go out and have a drink after work and go out on the weekends, and whether they're a blue-collar worker or white-collar worker, it affects everyone. And those people sometimes get on the road after they've had one too many drinks, and when that happens and they get pulled over, then they're charged with a DUI. So it happens to everyone, or could happen to every economic class.
Do you typically find that individuals are sort of concede that maybe they did drink too many when they got pulled over, or are they more apt to want to challenge it and fight it and say, I really wasn't intoxicated?
I'll see the latter occasionally. More so what I deal with is people who said, you know what, Jay, I made a big mistake. I shouldn't have had that many drinks and get behind the wheel. It's my fault. I don't want to get up there and lie and said I didn't drink. They just want help to be guided through, and obviously to try to minimize the detrimental effect that a DUI can have on you.
Well, let's talk a little bit about that impact. And I guess the first starting point is when we talk about a DUI, what are some of the parameters that police officers have and the laws that are in place relative to arresting somebody and charging them with driving under the influence?
Well, what typically happens is someone will get pulled over for a number of reasons: speeding, swerving, not having their headlights on. It's amazing what people tend to forget to do when they have had a little bit too much to drink. So they'll get pulled over. The police officer will obviously come to the car and begin to question them. At that point, the police officers usually smell alcohol on the breath, or there's some other suspicion that would allow the police officer to either conduct a field sobriety test or a breathalyzer test, which measures the amount of alcohol in the breath, which then converts it to how much should be in your blood. Right. So those are the main things that happen, once you're pulled over and the cop has suspicion to believe that you have been drinking.
In terms, we know the term DUI, driving under the influence, but what does that mean? What is the mark to which you are under the influence, and how can you actually be charged with a DUI? What's the bar to be charged with such?
That's a good question. We'll focus on alcohol, I think, today, but right. just a brief comment. You can be charged with driving under the influence of, for example, pain medication, prescription drugs, things like that. But as far as alcohol, there are two tests which I've just kind of talked about just a minute ago: the breathalyzer, the BAC or blood alcohol content, and then the field sobriety test. With the breathalyzer, it's a little machine that someone would blow into. And once they blow, it registers how much alcohol they have on their breath. Again, that translates into how much they have in their blood. Now, with that, the presumption is that if you blow a 0.08 or higher, then you are legally intoxicated. If you blow 0.06 to 0.08, then there is no presumption. A lot of people think that, oh, well, I'm under 0.08, therefore they're not going to charge me. Well, they can still charge you on the 0.06, 0.07 level. There's just no presumption if it goes to court that you're intoxicated versus the 0.08 or higher. The other way is what we call field sobriety test. A lot of people probably heard of this. Can you lean back, touch your nose, the finger, walk a straight line? Things like that are all tests designed to determine whether you are impaired by alcohol.
What does 0.08 mean? Does that mean that your blood alcohol your content is 8% alcohol to blood? What does that mean exactly?
That's exactly it. There's 8% of alcohol in your blood. Okay. And to be honest with you, I don't know why they came up at that number, but once it's determined that you have 0.08, then that is the presumption that you are legally intoxicated.
Now, it's my understanding, though, that there are different standards for minors as well as truck drivers in terms of that threshold limit of 0.08. I think maybe a minor is 0.02, and maybe even a commercial truck driver is 0.02 as well?
Correct. You're right. They have lowered the standard. For example, school bus drivers, anybody with a CDL can be charged if they have a much lower blood alcohol level and be found guilty. Yeah. That obviously operating a big truck and school bus, that driving kids around, things like that could be potentially a much bigger disaster if there were a wreck.
Let's take a break right there. We'll pick up right there. You can pick up right there if you want. We're going to take our first break of the evening. When we come back, more on the subject of DUIs. Would love to have you be a part of the conversation. Call, text, email to join in. We'll be glad to pass those questions along. Also, remember, an attorney is standing by right now to take your call, so would love to have you go ahead and pick up a phone and give them a call and ask your question to them. Also, remember, you can find the firm of Hollis Wright on Facebook as well as Twitter. Stay tuned. More of the attorneys coming right up.
I'm Carter Clay with the law firm of Hollis Wright. Thanks for watching The Attorneys on WVTM 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of this show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other specific legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family member. Or simply contact us by going to WVTM13.com and click on the attorney's link. Now, we know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on WVTM 13.
Welcome back into The Attorneys, dealing with the subject of DUIs. We'd love to have you be a part of the conversation. If you have a question you'd like us to pass along to our panel of experts, just call, text, email the information at the bottom of your screen. Carter?
Yeah, Jay, how easy, or I guess difficult, depending upon how you want to ask this, is it to have a .08 blood alcohol content level, meaning how many beers or drinks would you have to have? And the reason that I ask that is, you mentioned a minute ago that people tend to believe that if you have a .06, which is below the legal limit, that you cannot be found guilty of DUI, and that's incorrect, right?
Right.
And so the inverse of that, or looking at it from a different angle, what if somebody has a .09? We all have different tolerances. We all metabolize alcohol differently, and somebody who has a .09 may not show any signs of intoxication at all. Can they get out of a DUI under those circumstances?
They can. Now, you've got to go back to the intent of this. Those are just standards, and what I mentioned earlier, the .08, it just gives you a presumption that that person is intoxicated. Now, that can be overcome. That presumption can be overcome. And when you're dealing with .06 to .08, there is no presumption. So, and then under .06, there's the presumption that you are not intoxicated. So that doesn't mean that, oh, I blew a .05, I'm good, you know, because you could still be found to be legally drunk.
Right.
The real issue is whether you were so impaired that you could not safely operate a vehicle. That's what you're really looking at. Now, the .08 and all these field sobriety tests that we've talked about, those are measures for the police officer, if they're trying the case against you, the prosecutor, to use the police officer to testify that, yes, that person was too intoxicated to drink. To answer your question about how many drinks, there really is no set amount. It depends on a lot of factors. Someone that's 300 pounds, for example, might drink 6 beers and blow under a .08. Someone that's 85 pounds might have 2 beers and blow over a .08. I'm sure everyone's seen how alcohol affects people differently. You know, like I said, somebody could drink 6 beers and no one be able to tell they've ever had a drink. Other people might have 2 drinks and you can say, wow, that person is really intoxicated. Mm-hmm. So the idea is to, for the police officers or whoever to say, yes, that person has had way too many drinks to be driving.
Yeah, because I could envision a scenario where the individual passes the field sobriety test, he's not showing any signs or symptoms to the police officer, but then he blows a .09 or .10, and that would be, I guess, right for somebody like you to be able to point out that, yes, maybe he did technically blow over the legal limit, but he was not exhibiting any signs of intoxication, he just wasn't impaired.
Absolutely, and that happens. You know, people are pulled over and they're not, you know, legally intoxicated, but they do blow over the limit. So there's some things you can work with that.
A question we have here: must I be driving in order to be charged with a DUI?
No, that is a big misconception I get. I've handled several cases where people are parked in parking lots, and the cop, you know, comes up to them. It might be midnight or 11 or early in the morning, and the police officers come up to them and, you know, start questioning them. And I had a client I talked to yesterday who realized he had had one too many to drink, so he pulled in a parking lot to sleep it off, as he said, and he was subsequently arrested for DUI. So the real standard is, do you have the physical control and ability to drive the car? And what that means is, do you have the keys and does the car work? Now, there are cases out there that if the car is inoperable, meaning the motor's gone bad, you can't physically drive it, then it doesn't matter that you're sitting in it with the keys.
Right.
So that would be a defense to that.
Talk a little bit about the implied consent laws relative to being charged with DUI or being pulled over, because I think a lot of the viewers out there might want to know, am I required by law to take a blood alcohol test? Am I required by law to blow so that they can see what my blood alcohol level is? Am I required to undergo these field sobriety tests?
You're not required to do it. There's no law that says you have to do it. However, the implied consent law, basically when you sign up to get a driver's license, you all agree that if you're pulled over and you're asked to submit to a breathalyzer, blood test, urine test, you will agree to do that. So if you don't do that, they can't force you to do it. But what they can do is say, okay, we're suspending your driver's license administratively. And this is a good point to bring up. There's two aspects to every DUI case. There's the administrative suspension, what we were just talking about, and then there's the criminal aspect, which we've been talking about previously. So while you don't have to blow and you don't have to do field sobriety test, you can still be arrested and you can still lose your license because of the implied consent law.
And when you talk about the administrative suspension, is that through the Department of Public Safety, and what are the suspension timeframes involved there?
Correct. What will happen is if you have an Alabama state driver's license, then you get pulled over and arrested for DUI, whether you blow or don't blow. If you blow .08 or higher, or you don't blow, the police officer will submit your driver's license. He'll take it from you, submit it to the Department of Public Safety, along with a form called AST 60 form, essentially telling the department to suspend your license. Now, depending on whether it's a first offense or you've had multiple offenses, it'll be suspended anywhere from 90 days on up. There are some things that lawyers can do to help with that if you do get pulled over.
We've done shows on this before. I'm always curious, do you advise folks not to blow? I mean, to take the test, don't take the test? Where do you come down on that?
That's a great question, and one I've been asked hundreds of times. Prior to July 2014, which is when this ignition interlock, which we'll talk about in a few minutes, I believe, came into effect, the answer was always don't blow.
Okay.
Don't blow because it's easier to prove that you're not intoxicated if you don't blow. Right. Now, with the enactment of the legislation that went into effect July of 2014, it's better to blow. There's harsher consequences if you don't blow.
Really?
For example, on a first-time DUI offense, if you don't blow and you're found guilty, you have to have the ignition interlock device installed on your car for 2 years. Okay. If you do blow and it's under 0.15, then it's a 6-month time frame versus a 2-year. So that's just one of the ways that it's harsher. Right. What the legislations have done is saying we want everybody to blow to be able to determine whether they meet this above the legal limit or below it. And so what they've done is if you don't blow, they've made it more difficult for you if you're found guilty.
That was a consequence of the Jay Tidwells of the world advising people not to blow. Huh?
You're to blame.
So it's a tough question, really.
Yeah, I'm sure. Hey, time for us to take our final break of the evening. As we head to break, still time for you to get your question into us. Call, text, email. Join the conversation. Stay tuned. More of the attorneys coming right up.
I'm Tyler Vale with the law firm of Hollis, Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 411, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Rule 403 of the Alabama Rules of Evidence states, although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there is sufficient insurance coverage or assets to satisfy a verdict. The reality is this. The parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during a trial, there could still be resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys.
Welcome back into The Attorneys. One of the neat things about this show is that while we're on the air, an attorney is standing by. So the numbers that you see at the bottom of the screen, pick up the phone, call them. You can speak to an actual attorney right now. I would advise you to take advantage of that if you have a question. Carter?
Yeah, Jay, you mentioned the new law that kind of came into effect, I guess, in the summer of 2014. Talk a little bit more about some of the specific aspects of the new law that came into effect, other than what you mentioned before the break.
Yeah, the main aspects of the new law are what's called an ignition interlock device. That's really the main thing. Prior to July of 2014, if you were found guilty of DUI, didn't matter if it was your first, second, third, there was some period where you were going to lose your driver's license and there was nothing you can do about it. Now there is something that you can do. It's called the ignition interlock. It's good and it's bad. It will give you a mechanism to be able to drive to work, to places. But the bad is you have to blow in this device before you can start your car, and you have to blow every 15 minutes or so while you're driving the car. If it reports back to a court referral officer, and who ultimately reports back to the judge. So if you have had drinks and you blow in it, it's going to go back to the judge. So that will allow you to drive. Depending on whether it's your first, second, or third, you could still be facing a revocation or suspension of your driver's license in addition to the ignition interlock. But that was a big thing that this July law passed.
Now, as an attorney, I have to ask this question, which is how does the interlock ignition system ensure that the person who's actually supposed to be blowing is the one blowing as opposed to his friend that's sober standing right next to him?
They have cameras.
Okay.
So when, at least in theory, they have a camera, and when you blow in it, it can take a snapshot of whoever's blowing in it.
And I guess, does it record the time in which it was done?
Date stamps the picture, and like I said, all of that information is accessed by a court referral officer, or can be accessed. So if there's some suspicion that you're not blowing in it, somebody else is, they can pull it up, show a picture of who blew in it, and not only will you be in trouble, but that person can be in trouble as well.
Wow. Now, in terms of the new law, were there enhancements relative to penalties and punishment if your blood alcohol content was a certain threshold as opposed to 0.08?
Correct. The new threshold for enhancements is either if you don't blow, and I think we've already talked about that a little bit, or if you do blow and it's above a 0.15. If you blow and it's above a 0.15, you're looking at your double minimum punishment for jail time, for fines, costs, things like that. And in addition, extended periods of ignition interlock. For example, if it's your first DUI and you blow a 0.08 and you're found guilty, you have an ignition interlock device for 6 months. Okay? If same first DUI and you blow a 0.15 or higher, then that 6 months turns into 2 years. So it just jumped up the 2 years instead of 6 months, and also your fines and all that are increased doubled as well.
So it sounds like the law is recognizing something we talked about earlier, which is perhaps maybe an individual that has a .09 or .10 maybe shouldn't be treated as harshly as somebody who has a .20 or .25.
Absolutely. What the law, in my interpretation, is looking at is .08, you shouldn't be driving, but you're not falling over intoxicated. Whereas .15, .2, those things, you really have no business being anywhere near a car. And so I think the law is going to punish you more harshly for that.
About 3 minutes remaining, but I just want to get a question here. How soon after a DUI arrest should I contact an attorney?
Immediately, for a number of reasons. The administrative review, which we've talked about, the administrative suspension, you have 10 days from date of arrest to request a hearing. If you don't do that, then your driver's license is automatically administratively suspended for 90 days. So the attorney needs to meet with you, get the facts, and request that hearing within the first 10 days after your arrest. The other aspect of really any criminal case, or any case at all, the sooner you hire an attorney, the better off. The witnesses are fresher. Right. You might be able to track down witnesses that might be able to help your case. Things like that. The longer you wait, the harder it's going to be for you and the attorney to defend you. We
have less than 2 minutes remaining, but I just want to give both of you a chance, and we'll start with you, Jay. Just your final thought, a final charge to our viewers.
Yeah, it goes along with what we just talked about. The basic thing is if you've been charged or arrested with any crime or DUI, contact an attorney immediately. Go in if you want to, meet, sit down, make sure you get along and you trust that attorney, because you're looking for that attorney to provide you the advice and the best representation. So you need to be able to sit down and be able to communicate with that lawyer so that he or she may best defend you.
Right.
DUI cases have become more and more severe as far as the punishment and public perception of them. So it's very important to hire a good qualified attorney.
Right.
Yeah. We've spent most of our time this evening talking about what to do if you're charged with a DUI, but I don't want to lose sight on the public service that we're trying to provide here tonight relative to awareness.
Right.
Education is the key. If you're going to drink, drink responsibly. Don't drink too much. If you have had too much to drink, have a designated driver. Right. Educate your children and teenagers to feel comfortable in terms of approaching you as a parent if they are in an uncomfortable situation where perhaps maybe they've had too much to drink or they've had friends that have had too much to drink, and just educate them about, look, I would rather you call me at midnight and have me come pick you up rather than get in the car with somebody who's intoxicated and make them feel comfortable.
We're out of time. We're going to have to leave it there, but thank both of you for being with us tonight. Appreciate your time. Appreciate yours as well. We thank you so much for joining us as we wrap things up. The attorneys of Hollis Wright will still get back with you. If you have a call, question, email, use that information and contact them. Thanks so much for the time. We'll see you next week right here on The Attorneys.